Ready? 5 seconds. Start. In the background of this legal position, now we turn to the facts of the present case. The appellant was under suspension from 15/3/1999 to 21/5/1999. On attaining the age of superannuation, he retired from services of the respondent corporation on 1/1/2000. The learned single judge, after considering the rival contentions, disposed of the writ petition, issuing directions to the respondent corporation to settle the full salary and allowances for the period of suspension. It is clear from what is extracted above from the order of learned single judge that interest on delayed payment of gratuity was denied only on the ground that there was doubt whether the appellant was entitled to gratuity, cash equivalent to leave, etc., in view of the divergent opinion of the courts during the pendency of enquiry. The learned single judge, having held that the appellant was entitled for payment of gratuity, was not right in denying the interest on the delayed payment of gratuity, having due regard to section 7(3) of the Act. It was not the case of the respondent that the delay in the payment of gratuity was due to the fault of the employee, and that it had obtained permission in writing from the controlling authority for the delayed payment on that ground. As noticed above, there is a clear mandate in the provisions of section 7 to the employer for payment of gratuity within time and to pay interest on the delayed payment of gratuity. There is also provision to recover the amount of gratuity with compound interest in case amount of gratuity payable was not paid by the employer in terms of section 8 of the Act. Since the employer did not satisfy the mandatory requirements of the proviso to section 7(3), no discretion was left to deny the interest to the appellant on belated payment of gratuity. Unfortunately, the division bench of the High Court, having found that the appellant was entitled for interest, declined to interfere with the order of the learned single judge as regards the claim of interest on delayed payment of gratuity only on the ground that the discretion exercised by the learned single judge could not be said to be arbitrary. In the first place, in the light of what is stated above, the learned single judge could not refuse the grant of interest, exercising discretion as against the mandatory provisions contained in section 7 of the Act. The division bench, in our opinion, committed an error in assuming that the learned single judge could exercise the discretion in the matter of awarding interest, and that such a discretion exercised was not arbitrary. In the light of the facts stated and for the reasons aforementioned, the impugned order cannot be sustained. Consequently, it is set aside. The respondent is directed to pay interest at the rate of 10% on the amount of gratuity to which the appellant is entitled from the date it became payable till the date of payment of gratuity amount, the appeal is allowed accordingly with cost quantified at rupees 10,000. Stop.